Oh, he's not used to that.
No, I'm not. That's a new one. Welcome. June workshop for the Mayor and City Council, City of Taneytown. I ask Councilwoman Fuller to lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Councilwoman. Let the minutes reflect all council members are present and accounted for. We're going to start the evening review of the minutes from the May 8th and May 13th meetings. Is there any notes from the minutes that anyone wishes to make? Corrections, additions, any of the like?
No, sir.
We're satisfied? Very good. They will be up for adoption on Monday evening. Moving on, we're going to go to public comment pertaining to non-agenda items. We're going to stick with the recent tradition, the 3-minute time limit, as we get used to the new flow of things. I ask anyone who has any comment to make about non-agenda items to please approach the lectern there, state your name and address, and let us know what you think.
Barbara Cook, 314 Clubside. Well, I'd like to, at some point, speak about where Taneytown is now and where I see it going in the next 10 or 15 years. And there's no way to do it in 3 minutes. So I'd like to get permission and be given a time to do that later, sooner than later. So my time, I'm going to talk about a curious thing I did. I sat down and figured the median age of the council as it was last month, and the median age was 50 years old. And then I figured the median age of this council, and I got 37, age 37, a drop of 14 years. You can use that information as you please. And I'll use the rest of my time to talk about, before moving to Taneytown, I did a run through to see what it was like. And there are 2 things that I decided: that when I moved to Taneytown, I would get to know their inner working, because it seemed to be stuck in a time warp. And I grew up in a town of about 850 people, and as a kid, you were to be seen and not speak up. But little eyes can see a lot, and little ears can hear a lot. And the second thing is that if I moved here, I would spend as much money and time here as possible, because I would make it my home.
Thank you, Ms. Cook. Anyone else have any public comment pertaining to non-agenda items? All right, well, moving on then.
Hold on a minute.
Oops, I'm sorry.
Jim Parker, 54 Devania Road, Taneytown. A few months ago, it was mentioned that letters was going out from insurance companies that resembles official Taneytown. Well, I've got questions from different residents. Is it official? Do I need to respond? I told them it's just propaganda. If we allow something like this to go out, then why don't we allow insurance companies or what other people that would want to use our seal or whatever to be mailed so people would open it, think it's something important. It may be important to some people, but I don't think it should be represented by Taneytown. The second thing is, I had the opportunity to enjoy a baseball game down at the park last week, and I was really disappointed in the bleachers. There was a little child, about 3 years old, barefoot, running across the bleachers. There was nails up, screws coming up, and a couple places when you stepped on one end of the planks, the other end came up. So I would like the town to take some time to look at them and maybe bring them up to some type of standard. Thank you.
Thank you, Mr. Parker. Anyone else? Going once? That'll do it. I'd like to ask the council if there are any conflicts of interest pertaining to what's on the agenda today.
Yes, sir.
No, sir.
No, sir.
All right, thank you, council. Moving into resolutions, ordinances, and agreements. Up for approval on Monday's Sustainable Communities application. I believe Mr. Wyprek can kind of lead us on that.
Sure. Well, for Monday, what we're looking for is going to be authorization to sign the application and submit to the Department of Housing and Community Development. We hope to be able to submit the application later this month and not wait for the July council meeting. I'm trying to set up a group, a sustainable community work group meeting for next week so that we can finalize the draft and get it into DHCD. So Monday night, I'd like authorization to sign it and submit it once it's ready. And of course, if anyone has comments or concerns, suggestions, please let me know as quickly as you can so that we can get that input before the work group meets towards the end of next week.
All right, anyone of council have any questions regarding that? I know you just got the papers tonight, but you'll be able to read over it.
Just, I can elaborate a little bit more because not everybody was here when we were originally designated. The Sustainable Communities Program basically it makes the city eligible for a number of state funding opportunities and other programs. So to benefit from things like the Community Legacy Program, you need to be a sustainable community. We were designated such 5 years ago. Our designation actually has expired, but the state has, because of the circumstances here, given us some extra time to complete the renewal application. But we've asked for a couple extensions now, so we're really at a point where we need to get it submitted. But again, we did, some of you probably saw, we did an online survey a month or so ago with regard to some very short questions with regard to the sustainable community area, which is essentially the older part of the city. It's the historic district plus the residential communities of Fairground Village, Cloverberry, Tawny Village, the townhouse communities. So it's basically trying to direct resources where they're most needed within the city, and the state likes to layer all the different programs on the same part of the community for the maximum benefit. So that's what Sustainable Communities gets us, really just opportunities with the state.
Jim, do we have a figure on how many people responded to the survey?
I do not have that tonight. I do have a number, but I can email that out or share it on
Yeah, that'd be great.
All right, last chance for questions for Mr. Wyprek. All right, we'll discuss that further on Monday. Next, for introduction on Monday night, it's going to be Ordinance 07-2019, Amendment to Taneytown Zoning Code. Do we want Mr. Gullo or Mr. Wyprek to start us off on this one?
I'd be happy to, Mr. Mayor.
Yeah.
Okay, before I explain this, let me explain the circumstances that brought this to our attention. Late last year, we had an application from an individual who wanted to open an adult novelty store in one of the buildings here in the downtown area, the old Sheets building. And when you went through the code, it's a novelty store, it's a retail store, it didn't have any other definitions, and so therefore the permit to do that had to be granted. And later then, it was decided by the owner that they'd rather try to open the liquor store that is going to go into the new Sheets, and they were going through that process. At the time, the council and the mayor were made aware of that. It was on social media, and there was a discussion that, well, that can't be allowed because the city passed an ordinance that says you can't do those things downtown, more or less, downtown being the general area. And that's simply not true. We might have talked about it years ago, but it never got passed. There was never anything tangible to do that. So the directive was we should address these issues right now before we have any other situations come up. So what you have in front of you, amendment to the zoning code text, basically has three major parts as it sits right now. There's more parts, but basically the first thing is it starts to define adult entertainment activity. It gives a definition that would go into the zoning code, and you can see what it says, but it talks about commercial activity, and it deals with things like adult novelty stores, adult bookstores. We talk about strip joints, we talk about go-go bars, everything you can kind of think of in that genre in there. We also talk about massage parlors, things like that. And then we get into things that deal with gambling, like off-track betting and gambling and things like that. They're all defined as an adult entertainment activity. So once we define that, we basically now need to put it somewhere. So later in the ordinance, in the third section, we come up with a overlay district. Now, let me digress and tell you why we do this. We are not permitted to say you can't do this anywhere. Okay, that's just not allowed. If you did that, that would mean that when the zoning law gets overturned, they could put it anywhere they wanted. So this is similar to what we did with the dispensaries for the marijuana, which was an objectionable use that you didn't want downtown. And the way this is handled is you put it somewhere else. And so you define it so that it is very narrowly limited. So what this definition, this overlay district does, is it defines where an adult entertainment use can go. It is identical to what we did with marijuana dispensaries. So it first of all says it has to be in the industrial zone. And then you have to start doing the measurements that are contained in here. And basically it's so many distances from schools and churches and parks and things like that. And it gets down to the point where there's very few spots that it can go, but it can go there if somebody wanted to go ahead and do that. There's other designations and protections in here beyond location. There's issues about signage, that you can't have nudity or vulgarity on the sign, that basically it has to comply with the underlying zoning, and it complies with the top overlay zone. So you would never have a place where you would be able to have alcohol and adult entertainment, because you can't have alcohol uses in restricted industrial. So you get the idea of what we're trying to do. That would keep it out of the mainstream zoning and take care of it. We don't have a current pending application for this, but like we said before, it's too late once the horse is out of the barn. So that's the second part of this. While we were going through this, or that's the first part, two pieces. While we were going through this, we addressed the alcohol beverage package store issue. As you know, there's no new liquor licenses that can be granted into the Taneytown voting district, not just the city, but the voting district, because of population. We know that because it just went through a BZA hearing and they talked about it. And we're not even close to another one. It's based on population of tens of thousands. So we know what liquor licenses are available, and they're already applied for. So the idea was, why don't we allow them in areas, because down the road you might want a wine shop, you might want these things. Instead of making it go through a special exception, you'll just allow them as a permitted use. And we basically talk about where that permitted use would be in the downtown business district. Similarly, we've had issues in the past where people have inquired about tattoo studios. We don't have any definition of tattoo studios. So we kind of search for where could you say you could have a tattoo studio. As I just told you with adult entertainment, it's not in the code at all. So therefore, the argument can be made that it's not allowed at all. And if that argument is made, then we have a problem where somebody could say, well, I can put it anywhere. So what we need to do is designate where we would like that to go, because there is questions where people want to do that. And the thought would be, we've now designated that where that use, the tattoo studio use, can go would be in the general business district. So it's out that end of town, like the shopping center area and things like that. And the thought behind that was that those areas of town have higher rents, so therefore a business would have to be well funded and would be more likely to succeed, as opposed to just throwing it in a storefront that doesn't really pay a lot of rent, and therefore it's, you know, the idea would be maybe it's poorly managed and so on. We put the extra protection in there by saying you can't do it as of right. you'd have to get a special exception. So they go to the Board of Zoning Appeals. So that's what this is attempting to do, dealing with all the loose ends that we have. Questions?
So, the tattoo parlors are not a part of this overlay for adult entertainment?
No, they are not.
Okay, because that's what was confusing me about
Right.
this.
They are just a special exception in the general business zone, if you
Okay.
pass it like this.
Okay.
I have, sorry.
Yep, go ahead. Well, I was going to kind of explain the graphic that's on the council table for everybody here. Councilman Bigliotti asked if we would have kind of an illustration of what the overlay would look like if you superimpose it over the city. This unofficial illustration that you see is one that I put together back when we were working on the cannabis overlay. If you look at it, you're going to see kind of jagged shaded areas over majority of Taneytown. The way that it reaches out is the distance boundary that we require for this. Basically, what you're looking for are the pink that are not covered by a shaded area. That's essentially where this would be allowed. There's a few exceptions, and Mr. Wyprick pointed out to me that there may be a house back on Allendale that, there's going to be a boundary around that as well. But kind of looking at that, you can see how limited they're going to be on where they can put this. So this isn't official, it just kind of gives you a graphical reference of what an overlay might be looking like and how that'll be affected. And anyone else to review this after the meeting, feel free to come up and we can look at it as well. Councilman Bigliotti, you had another question?
A couple brief things. I think one may be a little more involved as a discussion, so I'll save that for the last if that's okay. I'd like everybody to turn to page 2, if they could, to lines 8 and 9, number 4, where it says, and I quote, "Any building, room, place, or establishment which provides for off-track betting, telephone betting, or satellite simulcast betting of wagering, betting, or gambling purposes." And somewhere in there, I'd like to include the words wireless or internet-based as well, because technology has changed since those kinds of definitions were used. And, if you say, well, you're not allowed to use telephone betting anymore, that doesn't necessarily mean that you have a landline providing internet at this point. I can pull out my phone right now and start broadcasting a wireless signal and say, well, now that's acceptable to bet because I'm using wireless, I'm not using a telephone line. So if nobody has any objections, I would like to add that caveat to it, that we want to include wireless and internet-based as a source of method for betting.
I think it's appropriate to cover all bases. That way there's no loopholes anyone can try to take advantage of.
Okay, we'll add on line 9, it'll say telephone betting, and then it'll be a comma, wireless or internet betting, comma, and then continue with the sentence. You'll get a revision of this for Monday, but that's what it'll say.
And then thank you, Jay. And then the other thing I'd like to bring up this evening is everybody will remember a couple of years ago when we were talking about downtown zoning, we were interested in the idea of allowing in certain areas a drive-through provision in case like a fast food restaurant wanted to open up in a certain area. And I feel that because we are currently tackling issues relating to that same section, I'd like to bring this up for discussion and maybe include that as an amendment in this. That, we go ahead and say, for the future, any, fast food restaurant or whoever that is interested in utilizing a drive-through would have that option. By creating the parameters of the widest possible extent to attract businesses, I think would be a proper thing to do. Now, in terms of the specifics of it, the size of lots or anything, I'd like to offer that up for discussion with everybody. But I think that at this time, it's probably a good idea to bring that up.
So I think it's a good idea in principle, but what I don't think it does is remove the need for a case-by-case visitation, because obviously every time any type of business utilizing a drive-through would want to establish itself somewhere, city organizations will have to come in and absolutely determine whether or not a drive-through is a good fit. I think that the only thing really left to kind of throw into the amendment is how you would word that, is what kind of jargon and language you would use to put that sort of preemptive notice in place, where it's like, hey, if you need a drive-through, we're going to work with you, don't worry about it.
Well, and that's what the BZA special exception would be. If you have those parameters, then there's a site plan process they have to go through as well. That'll kind of help narrow down the best fit, the most appropriate way to do it. But if we put it in as a special exception, if you want to drive through, you have to go to BZA, and they'll clear all these parameters and make sure that this is appropriate for where you're trying to put it.
All right. And for the sake of discussion, I know, Mayor, in the past, you had talked about having like a certain size lot, and I know Councilwoman Fuller had mentioned that making sure that, doing anything like that, you'd also have to have like an ingress and egress, like, delineated entrances and exits as well.
Correct, yeah. This was brought up a couple years ago initially, because there was someone with interest in the old Sheets property, and because they couldn't have a drive-through, they went away. I know the initial thought I had was the parcel had to be at least 1 acre in size, have ingress and egress on 2 separate streets that are of essentially wide enough that could be separated by a line for opposing traffic. So basically trying to pigeonhole this down to very specific properties that would be appropriate for this sort of a thing. So there's a couple ideas that we could put in there with it. From the zoning aspect, Mr. Wyprick, do you have any input or anything in that?
I have some concerns with the idea. Drive-throughs were prohibited from downtown with a code amendment probably, 17 or 18 years ago.
Right.
The reason behind that was basically to try to preserve the historic character of the downtown area.
Mm-hmm.
We have seen in the past where a business, a fast food restaurant, acquired 2 properties, consolidated the lots, built a fast food restaurant with a drive-through, demolished the buildings that were there.
Right.
So the question, I guess, for council would be, do you want to see a Roy Rogers across the street from City Hall?
Right.
Or where George's Own York is, or something of that nature, because that's what you potentially would be enabling. You can try to limit things with regard to lot size, multiple frontage, but you can't limit it based on a snapshot in time. So if there's money to be made to locate a, say a fast food restaurant downtown, it may be, the numbers may work for somebody to buy 2 or 3 properties that maybe have frontage on Warehouse and Baltimore Street, or Riffles and York Street, and demolish 2 or 3 buildings and, have a fast food parking lot and drive-through.
So if I may,
That may not be what we really want for our downtown.
so does your kind of idea sort of fall into what already exists as the special exceptions review with BZA? Is that kind of what you were saying?
Ask that question a little bit differently.
So the whole idea of, because what I think Councilman Vigliotti is trying to accomplish is a more seamless process for, let's say, for example, that had the Sheets property gone a little bit differently and had somebody that wanted to utilize a drive-through come in and actually acquire that property. I think what he's looking for is to make the process of making sure that they'll be able to have a drive-through and use it a little more seamless. And when he had first brought it up, you kind of said, well, that's what the special exceptions review with BZA is for. So are you saying that kind of already exists and that?
No, what he's trying to do is make it possible.
Right.
Currently, you cannot have a drive-through food service in downtown.
Okay.
So this would make it possible for them as a special exception. So they still have to go through a couple more hurdles, but as it stands now, if you come to us and say, we want to open a Dairy Queen downtown, we pretty much laugh you out the door because zoning doesn't permit it.
Right.
There are certain parts, if you consider downtown, you talk about the historic part, and that is part of the downtown district, but it also stretches kind of beyond that. The old Sheets building is considered the downtown zone.
Right.
The bank building there, the Exxon, all of that. You're not so much in the historic anymore. You're kind of out on the fringes, and possibly that could support a drive-through food service facility.
So then could we look for language that kind of merits, case-by-case review?
But you have to set parameters to follow. You can't just make it kind of arbitrary, we're going to make it up as we go. We have to have some parameters that we put in place for it.
Right. And I think in addition to some of the things that we've already mentioned, Jim did bring up the idea of parking, and I think having like an adequate parking area for whatever ends up opening up is also going to be necessary, because I think at the same time, That also helps to alleviate concerns that you're going to be demolishing multiple buildings for the sake of one restaurant. Or if you wanted to open up, say, a Roy Rogers, across from City Hall, without going the route of a drive-through, then you would have to create a restaurant that fits into the architectural and design standards of downtown. And that could be another layer of security that we use in place to secure or to ensure that there aren't going to be 4 buildings going down for the sake of an Arby's.
And that's true. We do have the Design Standards Review Board, and we do have a provision in the code that talks about adequate parking. Is that correct, Jim?
There are some downtown exemptions for parking. I don't know that they would necessarily be the case for a fast food restaurant. But I will add on to the discussion. Certainly, today with the code as it is, if somebody was proposing a drive-through business for downtown, we would, turn them away from downtown. But at the same time, we would say, but we would welcome you to locate anywhere in our general business district where it's a permitted use, and there is a lot of undeveloped general business acreage proximate to areas with high traffic counts, and we would love to welcome you to the city in one of those districts, in that district. So it's not like we're turning something away from the city. There are places in the city, and in general terms, when we look at Euclidean zoning like we have, we're thinking of where is the best site in the city, where is the best area in the city for that particular use. So if you think that the downtown is the best place for a fast food restaurant, then we should amend the code. If you think that other areas of the city are better suited for a fast food restaurant, then we should really leave it the way it is.
But at the same time, I do want to point out, not that this really changes anything, it's not just fast food restaurants, there's also banks and pharmacies that use drive-thrus as well.
And banks are addressed differently as well.
In what way are banks addressed differently?
They're already permitted as a special exception in the downtown code.
Okay, okay, gotcha.
And Jim, it was not my intent to imply that, we were deliberately turning away businesses. I mean, the whole point of me bringing this up is that we want to make sure that we have the maximum extent possible for conditions in a situation to try to attract more business.
And I'll jump in a little bit more. This really became an issue within the last few years. When Sheetz closed, Sheetz was an existing non-conforming use. When Sheetz originally built the 226, I think, East Baltimore Street location, gas stations, convenience stores, gas stations were a permitted use in the downtown business district. Some years after that, the city thought, you know what, gas stations aren't what they were 40 years ago. Now they're, 8 pumps and big giant canopies, and the glow of which you see from hundreds of feet away. That's not really appropriate for downtown anymore. And so the code was changed, but the existing gas stations were of course allowed to continue. Now when Sheetz developed their new site, they maintained their lease for over a year after they closed the former site. By doing that, the non-conforming use at the former site expired. And that certainly was with intent, because that way nobody else could come in with another gas station and competition to their old site. So very well thought out from Sheetz's standpoint. But the property owner was very unhappy that the zoning code had been changed while Sheetz had been operating there. And he felt like that was some sort of a taking or a devaluing of his property. That in part is what led to the whole proposal for the adult store. That coupled with the, at one point the liquor store was initially denied by the BZA, and then they reheard the case and granted it. So there's a lot of history to this drive-through discussion that really centers on one particular property. So I think all those things need to be considered, because once you put it in the code, whether it's a special exception or not, if the criteria for that special exception are met, the board should grant that special exception. It shouldn't be a matter of, I love that old building, I hate to see it be torn down, even though the applicant may be proposing to tear it down and they've met all the criteria in the code. We can't deny it just because, we might not like the idea or there are other concerns. If those criteria are met, the special exception really should be granted.
Right.
So it's a very dangerous path, I think.
So we have to be meticulous and careful about the criteria that we would establish for the special exception.
And you might even have to I'm not exactly sure what the code would look like for this one. I think you would probably have to define some lot specifications in the table of yard area and bulk, things like that, where you specify the setbacks and so on. I think you'd have to specifically reference that use there. And again, even that's no protection against somebody buying up multiple parcels and demolishing a bunch of buildings to make, their proposed business fit the criteria. There's a lot to consider with this one.
Well, I get what you were doing. I think I would have to avoid the drive-through part.
All right, so we can kind of think that over a little bit.
Yeah.
All right.
See what can be brought up with. So.
I wanted to bring it up for discussion because I just figured, while we were entertaining zoning code changes, it was worth looking into.
Right.
So to kind of finish up with what we need to do, aside from, let's just say as it is with the minor modification. If you want to make the major modification, you need to let us know, and you can let us know on Monday if you want it to be part of this. You can have a separate ordinance, and you can do this, separately. You could say, all right, I'm going to have another ordinance, and we're bringing that one to introduce next month. This one would go ahead on its normal process, and that one would fall behind it. It really doesn't make that much difference. The thought was we would be having the public hearing on this ordinance at your July meeting. Whenever you figure that, that's another question to talk about later. But we would have the public hearing, and the reason we need to know that in advance now is because we need to give the notice in the newspaper and all that, so we can't really wait too long. So that would
I'd like to move ahead with this one.
Okay.
So
Yeah, I think that's a good idea to just make it a separate ordinance.
I'd be okay with going the route of a separate ordinance.
So we can get some drafts to you for Monday, possibly with some ideas, and then you can decide on the hearing date when you decide on that.
Very good.
Thank you.
All right, Monday night, up for adoption will be Resolution 2019-07, our monthly water allocations. Any questions, concerns, general inquiries regarding that?
I have one on the signature page. The mayor's name has not been changed.
I didn't even catch that. All right, anything else? All right, that will be up for adoption Monday night. Coming up next is our city manager's report. Mr. Wyprecht, do you have anything for us?
Keep it brief this evening. Let's see, we already covered the zoning ordinance for commercial uses. We talked about the sustainable communities already. Just a quick update on Roberts Mill Run Stormwater Management Retrofit Project and the O'Brien Avenue Bridge. The county received 3 bids. They range from $3.2 to $3.9 million for the overall project. The range for the bridge component ranges from $384,000 to $494,000. So, and of course, the low bid for the bridge isn't the low bid for the overall project. It couldn't be.
Of course not.
So we have to do a bid review and have some discussions with the county. I'll be meeting with them tomorrow for at least some preliminary discussions, but just wanted to give you a little update. We did get some bids, so I haven't determined the per acre of impervious area treated cost yet, and that's something that the county looks very closely at as part of our the funding levels that are specified in our town-county agreements basically target a certain dollar amount per acre for these projects. Right. So hopefully this will fall within that targeted amount. So that's really about it for me.
Do we know at this point that they're still doing 80%?
Yes,
Okay.
that's in our, that is through the life of the NPDES permit.
Okay.
And so we're still under that first 5-year permit. We will be coming to you probably in the fall with a new memorandum of agreement with the county and the other 7 municipalities because of that agreement. We want to be ready with the agreement for when the new permit is issued. Okay. And other phase 1 permits have been challenged and are going through the courts, and the Carroll County permit has not been finalized. We've seen a draft and we have some general expectations on what we're going to need to do, but the memorandum of agreement runs the life of the current permit. So if our new permit is delayed, we operate under the existing permit until the new one is effective. Okay. So our agreement could actually run, instead of 5 years, it could run 6 years or 7 years if the permit gets challenged. So it's a little open-ended, but we want to be ready with a new agreement so that we've got everybody on board and can just execute it as soon as the permit is ready.
Go ahead, Councilman.
You sure?
Yep.
Well, thank you very much. I know last month we had some issues with drainage on Bancroft Street, and there was mention that we were going to be looking at the rest of the area. Has that process been, is that process underway? Is it something we're still slated to do?
We're hoping to get a proposal from another company. We've only had one bid so far to televise that system, or to clean and televise that system. We'd like to have another bid or another proposal before we move forward.
Thank you.
Any other questions on the city manager's report? All right, department reports. They were all in your packets. Any questions we can ask Mr. Wyperk out of that?
And Mayor, I'm not sure if it would be under new business or this would fall under the departmental reports, but the memorandum we've received about the dump truck purchase, is that something we should be discussing now or later under new business?
I was anticipating new business for that.
I can hold off then.
All right, we'll bring it up then. Moving on, if we would. Legal report. Mr. Gullo, what do you have for us this evening?
Mr. Mayor, I am pleased that I can finally present and put some closure to something that's been dealing with the city for several months now, and that is the issue with the Taneytown Police Department. And so in front of you, you have a quite voluminous report, and I'm not going to read everything, although it would probably be easier to do so. But what I wanted to do was walk you through it, explain it as we go. I don't really expect any questions or any discussion since you haven't had a chance to really digest it. You can have a chance to do that, and if you have any questions, we can do that privately or we can do it next month. So, but I did want to walk you through it. So the title is Inquiry into the Taneytown Police Department January 2019 Incident and Related Matters. And it starts off with a background section, and as you know, this started in February 9th, where the mayor and council had a meeting regarding what had just happened when the Federal Bureau of Investigation executed a search warrant on the Taneytown Police Department. and then subsequently the former chief of police, William Tyler, resigned on January 30th. So the council and mayor met on February 9th to get a handle on what was going on. Things were happening very fast. A lot of it was sealed and done in secret with the FBI, so we were not aware of a lot of those things. And we basically were tasked, and when I say we, the mayor and council tasked the staff with putting a task force together to deal with several issues. And we hammered those issues out of what is it that we wanted to know, what was reasonable to get to know. And so they basically, at the time, council came up with 5 major issues that you wanted to know. You wanted to report back. That's what you're going to have tonight on these 5 major issues. The first issue is you wanted to know whether any additional Taneytown personnel, Taneytown police personnel, were involved with the incident that was under investigation by the FBI, because at the time we did not know. So you wanted to know that. You wanted an accounting of all the weapons and equipment of the Taneytown Police Department. You wanted a review of the hiring and training records of the Taneytown Police Department and the personnel there. You wanted an audit of all the contents and records of the Taneytown Police Department evidence room, and you wanted a review of the policies and procedures and general orders of the Taneytown Police Department. These were not just pulled out of a vacuum. These were the subject of a lot of deliberations, and the thought on the deliberations, so we're clear of how we did it, is we knew that we had one actor, which was the former police chief who was involved with the FBI at the time, and we wanted to make sure that anything that dealt with the public safety of the town was dealing with, and anything that dealt with property or wrongdoings were basically going to be dealt with. And that's how we basically went this out, realizing that it was going to be a huge task that not only internal people needed to be involved in, but for transparency and independence sake, we needed to get external people. So I give you a summary of the people that were involved in doing this. Aside from myself and the acting city manager and acting police chief, Lieutenant Etzler, we also hired the services of Kevin Karpinski, who you're familiar with as a special city attorney. He deals with police matters and employment matters. And we were basically the core of the task force. But we needed outside expertise, and so the outside expertise that we used were the Maryland State Police, the St. Mary's County Sheriff's Office, the Frederick City Police Department, the Maryland Police and Correctional Training Commission, and DeLone and Stang, which is the city's independent auditing firm. And I'll show you how those fit in as we go forward. So basically, this report, you need to kind of understand what it's going to tell you. It comes up with findings, meaning the facts are there, and the reports are attached so that you can read the reports for yourself of what the facts do. It does not contain recommendations. We made some changes as we went through. There just was obvious that these things need to be done, and we recommended the implementation, and Lieutenant Etzler took care of it. But this report does not have a list of these are the things that have to be done from here. It's basically management's job, both the city management and the police department's management, to follow up with these things. They know what they are, and move forward. So you will not really expect another follow-up report from the task force. This is it, basically, the findings. So that's your background. I'll go through each item just in general so we kind of clear and then the public can hear it as well. So item number 1 was to determine if any additional Taneytown Police Department personnel were involved in the incident under investigation by the FBI. And it was pretty clear early on because there were 2 search warrants executed on Taneytown Police Department personnel, the Chief William Tyler and another officer. So it was pretty clear there was possibly another officer involved. Let me digress a little bit, and I have it in here, is that any officer in the state of Maryland that is not an elected or appointed chief is protected by the Law Enforcement Bill of Rights. The Law Enforcement Bill of Rights gives certain procedural rights to police officers. So what that means is if a police officer becomes under investigation for something, they have to be told what it is, they have to be allowed to have a copy of the investigation, they have to still be on paid leave unless there's certain exceptions, which is not here, and there is a process by which if there's punishment to be given, who gives it, meaning it's done by the police chief, and what the remedies could be for the officer, meaning they could say, I don't like the punishment you're giving me, I'd like a hearing board. And a hearing board is made up of other police officers from other agencies, and it's a trial board. There's a trial in front of it. And they come up with a recommendation, and then it goes back to our police chief to carry it out. Punishment could be anything, and this just doesn't happen in bad cases, it happens in little cases, but punishment could be loss of pay, demotion, loss of vacation, all the way up to termination. So those types of things. Because that process exists, I'm limited in what I can tell you. I'm limited in what we can disclose. And again, there will be a result of this process, but it is still ongoing. So realize that when you read this, you're going to say, well, I really wanted to know. Well, first things you're not going to know is who the other officer is. That's something we can't disclose. So in the report, as with the federal government documents that we got, the officer is entitled Officer 1. So our inquiry into this, we worked with the FBI on this and the U.S. Attorney's Office, and we found that there were only 2 personnel involved, Officer 1 and the former police chief. That was it. There was no other officers involved in this. And we found that there's no other investigations into anything else or any other officers. And throughout this entire report, no matter what we handled, there was no even shade of possible wrongdoing by any other officers that are here. So that is what I believe you wanted. And the line in here, it was also clear that no other TPD personnel were involved or implicated in this matter. So that's what you should have wanted to know. In order, and I'm trying to highlight who helped us out with this, in order to do the investigation into Officer 1, we did not do that. It has to be done by a sworn law enforcement officer under the LEOBR code. And obviously, we wanted somebody who was going to be outside and impartial. So the city executed a memorandum of understanding with the Frederick City Police Department. And Frederick City Police Department's large enough that they have their own Office of Professional Responsibility. And so they assigned 2 officers, the head of the Office of Professional Responsibility and the head of the Criminal Investigation Division, to look into this. They're the ones that performed the investigation, hands off from us. We were given the report at the end. Our people were obviously interviewed. There were several other people interviewed. There were FBI documents that were under seal, so we're not really allowed to share those, but all those documents were interviewed, and they came back with basically saying that there were 2 rules of conduct that the Taneytown Police Department operates under, which were violated by Officer 1 because of this incident. And so because of that, the investigation is concluded. The investigatory report is personnel, so it can't be given out, obviously. And the LEOBR process as to Officer 1 has begun. So that it really was, for our group, and I hope for you, really what we wanted to know. That our officers, it was an isolated incident with 2 officers. Okay, the second thing we needed to talk about was item number 2, is account for all the weapons and equipment at the Taneytown Police Department. And obviously, in today's day and age, weapons are an important thing. This entire incident with the FBI, regardless of what the rumor on the street was about weapons. It was about 2 weapons. And as in the beginning of the report, it was about 2 automatic rifles. Ruger rifles is what they're called, the manufacturer. That's all this was about. I'm not minimizing it, but it wasn't the things that you hear on the street, that it's this widespread corruption. It was about the inappropriate sale and transfer of those 2 rifles to those 2 officers. Plain and simple. It's a federal crime to do that without the proper, if you could do it without doing the proper steps, and that wasn't done. So obviously that made us back in February concerned of where did these weapons come from and what else is going on with weapons down there. We can tell you that the Ruger rifles in question were purchased by the city in 2003. So it was simply as purchasing a shotgun or a handgun or anything. They were purchased by the city. They were put into the armory, and we say, why would the city need such a rifle? Well, back then it was 2003, 2 years after 9/11. Everybody was concerned about different threats. And one of the things that was going to happen was going to be a patrol rifle program, and they bought these thinking they would get trained and they would be able to respond with those. That never happened. They never used those weapons, and they just sat in the armory. Obviously, those 2 weapons are no longer in the armory. They're accounted for, but they're gone. They were seized by the FBI, ATF, never to be back to the city again. In addition to the Ruger rifles, we obviously have other weapons. Handguns, shotguns, and rifles that are down there. All of those are inventoried by the police department, because who has what weapon is serial numbered out, and who is trained on what weapon is all figured out. Those records were seized by the FBI, but we were able to verify that all of those weapons are accounted for. So obviously there's nobody walking around with an empty holster. They're all accounted for. In addition to that, and what you saw in the newspaper at the time, was references to a 1033 program. They called it a 1033 weapons program. The 1033 program is Section 1033 of the National Defense Authorization Act of 1997. And what that Authorization Act does is it allows local police departments to get surplus military property. It's not just weapons. Everyone in the county, all the police departments, all participate across the United States. They do. Things from tents, generators, Humvees, cots, I mean, all those things, and yes, weapons. Our department participated in that program, and we received 12 Colt M16A1 rifles. Those are also automatic rifles, can be converted to automatic rifles. They came to us in semi-automatic form, but they have the necessary parts to convert to automatic. They came also with the accessories and the optics to make them usable. We also have 3 Winchester 12-gauge shotguns that came from this program. If you look at the weapon itself, engraved on the side is property of the United States government. Those are government weapons that we happen to be holding. Those weapons have never been used, never been issued, never been fired by us. They are Vietnam War era weapons, literally, and they are in such condition that they're not usable for us. When we went as the police to institute our rifle program, we purchased new rifles, rifles that are not automatic rifles, rifles that are more accurate and up to today's standards. So they sit there in the police department, and those are all accounted for on several different, we account for them every year. The Officer 1 is the person who does the accounting. So obviously we were concerned to match with serial numbers with that. But the Maryland State Police is the custodian, if you will. Come from the government, but the State Police Law Enforcement Support Office is the one who we turn in the accountings to, the auditings. And when they heard this happen, they said, we want to come up and do an eyes-on inspection, which they performed on March 26th. They came, every gun was inventoried, every gun serial number matched, every gun was photographed, all guns were accounted for, all guns were present. Additionally, since they were contained in the evidence room, and we'll get to the evidence room later, but since they were in the evidence room, we inventoried them as well through the independent auditor. So they inventoried everything in that entire room, so they were inventoried twice, and they were still there the second time as well. So that is the story with those weapons. Now, as far as accounting for them, we were able to account for all of that, but that is not standard procedure, meaning the police department account for their weapons, but the city itself does not account for weapons, flashlights, things like that. You know, we basically account, and I mean account, with the finance department, a schedule of property that's depreciated. So we depreciate police cars and generators and things like that. There's a schedule for that. But although these items are sexy, they're guns, they're a de minimis value that the city doesn't carry them on their schedule of depreciable items. Like we don't carry shovels and rakes and things like that. So one of the things that going forward is we might have to have some type of accounting system that's not finance accounting system. To start that, the acting chief, when we kind of came to this and it came to a head, we said, we need something done. He issued an order to all the department personnel, bring every piece of equipment that you have that's issued by the department back in, and then they'll be reissued to you just like in the military. You have this, you have that, you have this, you have that. That's what this officer has. That may have been done in the past, but those records aren't attainable because former police chief and Officer 1 were the ones that did it. So we wanted to have new records for going forward. The last thing to deal with is it was noted that when the former police chief, William Tyler, resigned, he brought a significant amount of equipment back to the city on 3 different occasions. And a list of all that equipment is in here. You don't have anything that has pictures. I figured you don't really need to see the pictures, and they're not going to show up anyway, but you can see lists and lists of equipment. And they weren't guns, except for his duty weapons, but they were things like GPSs and binoculars and flashlights and uniforms, and the list goes on, but just a significant amount of equipment, and it was returned to the city. What I'm telling you is it's not like the military where we have some other list to say this is what you brought back and this is what you were issued. That doesn't exist. So we believe that based on what I've just gone, all the weapons for the Taneytown Police Department are accounted for. They're where they need to be. These are weapons which we own or we have custody of because they were the government weapons. They are not evidence weapons. Okay, we'll get to that in a minute. Item number 3, we needed to review the hiring and training records for all TPD personnel. There was never a thought that we had hired people that were not qualified, but we wanted to make sure that the people who were on the street were qualified and went through it with independent eyes, because William Tyler and Officer 1 were the ones in charge of hiring, background checks, and training. So anything that was touched was another set of eyes on it. The city got really involved in this. Not only did we have the city personnel start coming in, our human resource director, Clara, had to get involved because part of the records are housed in this office, meaning the city office, and part of the records were housed down at the police station. And the reason for that is in the past, they were all at the police station and a directive was given, bring them up to the city. And that sounds simple, but it wasn't really thought through, so they were mishmashed everywhere. The organization that does training and certification is the Maryland Police and Correctional Training Commission. And so we contacted them and asked them could they come out and audit our training records. That is not unusual. It might be unusual to ask for an audit, but they do that every single day, everywhere. They audit training records and certification records for police officers all over the state and for correctional officers all over the state. So they came out, they have an auditor, and they came out and did an audit of our records. And they go back 3 years. It's just like any other audit. They tell you exactly what they're going to be looking for, and you go through the files to find them. We're not talking about going back to like high school records. We're talking about, was the background check done? Was the credit report done? Was the training record done? You might have sheets where they say, yes, 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 they're all done, but when you go to the part where are they? Well, that one's missing or that one's missing. That's not uncommon, okay? It's not uncommon to have incomplete. It would be uncommon if everything was missing. What the bottom line with this was that they believe that all of the training for the officers that came in was given, everybody has the training that they need, and that the records are substantially complete. They issued a finding letter, just like we get for our audits, our financial audits, of things that need to be improved upon because maybe Officer 3 doesn't have his credit report in there and it was somewhere else and they need to be inserted. But when you review that and a copy of their findings is enclosed in the report, you'll find that it was minimal. It was a de minimis type of thing, and there's going to be correctives. We have an opportunity to correct that, and again, that's something management's going to deal with. So the task force can basically say, based on what we have, all the officers that are protecting and serving the citizens of Taneytown are properly trained, they were properly hired, and they have the proper qualifications. So we should never have this problem moving forward because as we hire new, these are all done, so as we hire new people. As a byproduct of this, just to show you that there was benefits that will last in addition to this, the issue of where records are kept was resolved once and for all. The city manager made some decisions, and basically, if they're HR records, like the same kind the public works people would have or any of the city staff would have, they're housed in the HR department. If they're training records, they're going to be housed down at the police station because they're the ones who know what they need to do. It's not only good for us, but it's good for the employee, because if you're looking for another job, when they come to look at your jacket here, it looks bad if it's incomplete. It looks like you don't have the training. It could affect your future employment. Disciplinary records will be kept in the city's HR files in a separate system, and copies of them will be kept at the police station as needed. Meaning if you're written up for an incident of an infraction, it may be in your file here, separate from your personnel file, because it may go away, type of thing. So, okay, we're wrapping up here. Item 4, an audit of the contents and records of the Taneytown Police Department's evidence room. So I want to be very careful in how I explain this. I will say at the outset that the audit of the evidence room found that it was in substantial compliance based on what we all reviewed and what you'll see there. How we performed that audit was we needed to first, we thought we were going to go to the Maryland State Police, which is what we said. Can you come and perform an audit for us? And they said, sure. Give us your policies and procedures about how you keep your evidence room, and we'll be able to go in and pull something off the shelf and say, yep, it matches your policies and procedures. Well, there was our first problem. We didn't have policies and procedures that were written. They might have been, but former police chief and Officer 1 were the ones in charge of the evidence room, the only people that accessed the evidence room for the foreseeable past. So what you had was our inability to have an audit. So we changed our tune, and we said, well, we're really not looking for an audit. We're looking for an inventory, meaning we want to know every single thing that's in that room. And the state police said, well, that we do audits. We don't do inventories. So we talked to our independent auditors, the people that you know, they come in once a year, they sit here. They don't work for the city. We pay them, obviously, but they don't work for us. They're given independent opinion. And their personnel came and worked with Mr. Wieprick and with the acting chief, because the acting chief is the only one who has access to the place ever since the incident worked down. So he had to be there because every evidence bag was being handled. The condition of the evidence room, although everything in it was substantially accounted for, was disorganized would be a generous situation. It's probably like I keep my garage. I can find the stuff, I know where it is, but you'd never be able to find it. And that shouldn't be, okay? You would think it should be very organized. And that was a huge problem. You would think that it would be something just like spring cleaning, but it was a very big problem to tackle. And so a couple things had to happen, and I really want to focus on this because that evidence is key to all the cases that are pending. I mean, we want to make sure it was done right. So the acting chief asked the city manager, can we expand the evidence room? And they did. They built shelves, they took the records room, and so instead of this tiny little room, now there's 2 tiny rooms. And we built shelves in it, and basically as you took one piece of evidence out and accounted for it in the books, you put it back into the other place and put it in a numerical order and something that could be done. I could bore you with how it was done in the past. The problem is, to be realistic, there's 3 different ways we accounted for evidence going back 9 years. We had written logs. We had a system that was used for a couple years, in the late 2000s. There was a different system, and now there's the system we use now. So it really wasn't as simple as, hey, why can't you find it? It's like, well, what year is it? What book do I look in? The way it is. The biggest problem, like my garage, is we never got rid of anything. Everything was there forever, almost. Stuff from the 80s was still found in there. Stuff from when the acting chief was on the street and had cases, and he hasn't made arrests in years because he's not a patrol guy anymore. So we had to come up with a policy of how we deal with this. The city manager and we were involved with our outside counsel at that point, Kevin Karpinski, and we came up with different categories. Obviously, evidence that's currently pending, evidence of things that are on appeal, evidence of cases that haven't been filed yet, and old evidence, evidence that's already been adjudicated and should have been disposed of. Old evidence that should have been disposed of was then divided into, is it have any value? Is the value de minimis? For example, I gave you in the past an old wok or an old frying pan. That's de minimis. We're not going to fool with that. Or does it have value, in which case we need to talk and try to contact the owner and say, you can come pick up your property. And we put a procedure in place, which has not been executed on yet, where you'll get a letter, you have 30 days, come in, you don't get your property, it's going to be disposed of. I think probably every drug that we ever seized was still in there. And to the point where the acting chief said, well, I'm going to call the crime lab to get rid of it, and the crime lab said, we don't take that, you have to have a contract with a get rid of drugs R Us company, I don't know what they call that, and we don't have one. So that tells me we never got rid of any drugs. They're all there, you know, they were all accounted for, they just shouldn't be there. We didn't need these types of things. And I bet half the bags are full of oregano anyway. So I mean, you don't really know whether they were drugs or not. So, at the end of the time, I use the word disorganization and disarray in the fact that everything is accounted for, but it probably wasn't like we would like it to be going forward. So what you have attached, again, I spared you the pictures, is the audit report where there's going to be several columns. There's going to be like tables. And what we asked the auditor to do was match it up, and you'll see in there what the formula they used to match these up was pull everything out of the evidence room and match it to the log. Now I know what was in there. Now go through the log and tell me everything that is missing because it doesn't have anything accounted for. And that we thought we were set. That was what we're doing. Well, then we said, well, we need some more categories. What's in there that's not in the evidence log? Because you would have thought everything in there was in there. So you'll have different charts, and it looks like there's a lot of things, but when you consider the volume of the things that were in there, this is not a lot. And the things that were not accounted for, meaning they were in the evidence room but not in the logs, were always confined to property that was brought back from the state forensic team. Meaning there's a crime scene, the forensic lab comes in, they take all their stuff that you see on CSI, they take it to and do their stuff with it, and eventually they bring it back. Well, that was never logged in, as it would be the normal situation is where the officer takes it and he does his own thing. So they're all accounted for because we found them all, but they just weren't in the logs. A lot of things that could say, hey, they're missing, because there were things missing, would be that they could have been returned, but they never were marked on the logbook that they were returned. So we don't know that. So eventually we had to come up with, well, what about the things that are missing or unaccounted for? Is that something we should be concerned with, or is it so minimal it doesn't matter? And we came up with several categories: guns, drugs, money, and jewelry, right? The big things. If we saw those were missing, they got noted in there in this report that you have in front of you. There was no appreciable amount of that missing. If you could say, well, there were drugs missing. Yes, and the description in there might have been envelope with green leaf in it. It could have been oregano, and somebody said, well, we don't need that anymore. We don't know. But the important part was we did not notice, and you will not see a pattern, meaning all the money was missing, or there was lots of money missing, or drugs were missing, and they were being, that's what we heard the rumors, the drugs were being missing and sold on the street. That's just not facts. It's just not the case. There's no pattern in here any more than if I went through your place and said, show me your collection of whatever, and you'd be like, oh, well, that one's misplaced, but it's here somewhere type of thing. The bottom line is, this was a very tall order to do. And the people that did it really should be, they spent 2 weeks every day going through this, dealing with it. They need to be commended. But we can now say that we have a secure space, it's in an order, but there's still more that needs to be done because it's all categorized, but it still needs to go through the system and be dealt with. And again, management has some discussions for you about that, of how to deal with it, but we're comfortable that the evidence room was secure. Things didn't come out of the evidence room, disappear, get stolen, get sold. That just wasn't the case. The last item, item number 5, review the policies and procedures and general orders. There came some question about what this was about. Why were we doing that? Well, that was twofold. Number one, all the policies and procedures and general orders were issued by former Police Chief Tyler. So we needed to know what those were. Were they adequate? Were they up to snuff? And we really were looking at what are the policies and procedures on dealing with property. Is there a policy and procedures that says you can buy a weapon, any kind of weapon, automatic, handgun, or whatever? Is there policies and procedures that says that? When we started going through the book, we're talking about a book that's this thick, okay? Again, it was the same team I mentioned, the outside attorney. We had sent it to St. Mary's County for their sheriff's office to do it. And the reason why, they're very well respected and they're far away, meaning that we don't have any backyard rivalries or anything that we wanted an opinion of. What do you think of our procedures? And they basically said we looked through them and they need to be updated comprehensively. It's not that they're not good, but they could be better. They're missing certain things. And they're not really organized, like with a table of contents. So if you were an officer, you might have to go through the book to try to find what it is. There's also things in there that needed to be updated, like what about the sale of property? That's not in there, but it was done all the time. You retired, you got a new weapon, you were offered the opportunity to purchase your old weapon. That's done all over the places. That project, we said, we're going to get together and we're going to knock this out in one day and say it's all done. Well, the reality of the situation was it was overwhelming to do this. We spent 6 hours one day going through this and said, we're going to need more time. And then we realized we didn't have to finish this to give you the report. We can just tell you that what we need to do is go through these. And the process that we're using is we're using a CALEA certified agency. CALEA is a law enforcement certification agency. We're picking a police agency that's been CALEA certified, taking their policies and procedures. It's a good thing when you're CALEA certified. That's what you want. We're taking their policies and procedures, going through them, taking what we like, matching them to what we have, and we're going to eventually have one. That comes to you. If you look through the city code in one of the earlier sections that deals with departments, policies and procedures have to be approved by the city council. I don't know when they were. They haven't been since I was here. So that project will go on. Our goal is we want to get that done by the end of the summer. It's important to have buy-in from the officers because we can't just say, well, here's the new policies and procedures. They need to know what was changed, what's different. I mean, it's more than it just seems. But all in all, that is something that's going to benefit the city too. So the last page I have is the summary page. And, you know, I'll just read the 3 paragraphs so that I can wrap it up. The rest of the entire report are the appendix that are references, so you can see what you want to see in there. But the summary says the task force performing this inquiry believes that the goals of the inquiry have been met. While many items must still be addressed to correct or follow up on the matters contained previously herein, the scope and depth of the inquiry satisfies the directive of the mayor and city council on this matter. Based on the inquiry, it appears that the circumstances which triggered the inquiry were an isolated incident between 2 identified TPD personnel, William Tyler and Officer 1, and that while certain improvements can be made to the reviewed areas of TPD, no related or unrelated deficiencies, misconduct, or inappropriate behavior were discovered. It is clear that the members of the TPD take pride in their duties and strive to offer the citizens of Taneytown their best service and protection at all times. Their dedication to integrity and professionalism is evident in the support they gave throughout this inquiry, and they are to be commended for their professionalism and forthrightness. So that's hopefully that. If you have any questions off the top of your head, I can take them, but otherwise, maybe even stew on this for a month and we come back and you let me know you want to talk about it and I'll be prepared.
I have a few questions. The first one that I have is the Vietnam era shotguns you mentioned. Do we have any plans to get rid of those?
Vietnam era machine guns,
oh, okay.
M1A1s. Management's talked about it, that we want to deal with them,
yeah.
But it wasn't part of our goal to try to do that. But
gotcha.
They're taking up space, they're not going to be used, and I
Okay.
think that was the goal, was how can we go about giving them back?
Right. The next question I have is you mentioned how, you know, when officers are issued equipment and things like that, we don't really have like a CIF that holds you accountable line item by line item.
Right.
Is this something we want to change moving forward? Is that part of the policies and procedures conversation?
I think it is. I am sure that there is something like that if you're a new hire.
Yeah.
Here's your vest, here's your
Right.
this, here's your that. The issue becomes as new equipment comes out, how do we account for that?
Right.
And it's sloppy accounting. That's management job. So I would imagine that, and I know that the acting chief has already, as I told you, started that and is going to continue that as we go forward.
Okay.
One of the, I mean, I didn't mention this because it's not really relevant, but there is stuff just everywhere at the police station. I mean, you go in the locker room and you run into bikes. You go down the hall and you fall over Roscoe P. Coltrane's laser or radar gun.
Radar gun.
You know what I'm talking about in the 80s? Literally, that's what it looks like, okay?
So would you say our station suffers from like a space issue? Like, is there definitely a clutter problem?
Well, here's the thought that my opinion is that the clutter problem is one that I'm sure people would say your garage probably suffers from one because you don't get rid of anything, okay? If we went through and got rid of the things we don't need, which is one of the issues that the acting chief is dealing with, is to go through and say we don't need boxes of old camera systems.
Right.
And as part of our process, we're going to get rid of them. You'll have a lot more space. And that goes to your question of, you know, what else is there and how they're issued. When things are old, I think that, again, this is my supposition, but nobody wanted to get rid of it because they didn't know what to do with it.
Yeah.
So they just set it aside, say, well, I won't be responsible for the guy that got rid of the 1980s radar gun. Okay, and it just sits there and sits there. But that needs to happen, but there are bigger issues going on down there, which is why we didn't implement these. I mean, there's a manpower issue down there of doing the job of being out on the street, and so there really isn't time, like our lives, time for spring cleaning at the same time.
My last question is, so you mentioned an inability to dispose of drugs that were being held in the evidence room. From what I understand, Taneytown Police Department was always the go-to site if you wanted to dispose of prescription drugs. How were we doing that?
I believe that's like a contract with like a company that comes in, you know, you put it in that box.
Okay.
And I think somebody comes
Okay.
and does that.
Gotcha.
Meaning we don't do it.
Right.
So when I mean drugs, I mean illegal drugs.
Right. Okay.
Any more questions from council?
Do we, as council now at this point, have anything that we need to act on with respect to this report? I mean, is this something we need to vote on to accept? Are there next steps that we should be taking, even though you'd mentioned that management has the obligation to pursue certain avenues?
I don't think the council needs to do anything except determine in their minds whether this report solves the questions in your mind that you had. Are you comfortable with what it tells you and what it tells you about the department, what we're telling you about that? If that is what is done, then I don't think you need to do anything else. You will play a role in the policies and procedures. You'll need to play a role in how the personnel situation gets dealt with, which affects the evidence room and things like that. You'll play a role in management of what management can do to solve these problems. But if you're comfortable that this report solves the problem, I believe that's it. It's important to note that the saga isn't over, even though you're comfortable. The FBI investigation may be complete, but the sentencing for a former police chief is now going to be in September, so that's postponed until then. It doesn't affect us. The LEOBR process for Officer 1 will be ongoing. We'll let you know what we can let you know when it is, but we don't really know at this point in time. And then there's all the other things that still need to be done, as we talked about with the councilman, of cleaning up, getting rid of, and doing that. So unless you're uncomfortable with the results after you have a chance to study them, I would say the matter's put to bed.
Thank you.
Nice.
Sir, I have a question. Jay, is Officer 1 still on paid leave?
Yes.
Okay. Is there a time limit on that?
There isn't a time limit like he'll be on it for so long.
Right.
What will happen is Officer 1 has been notified of the findings and notified of the chief's recommended punishment, and he has a few days, they're still happening, to make a determination of to accept the punishment or to request a trial board. He will be paid through the trial board process, and at the end of the trial board process, depending on what the recommendation is, then the punishment would be implemented and then pay could cease. So it's on the horizon.
Okay. Council take some time over the next couple of weeks to go over this report in as much detail as you can muster. I understand it's going to be rather dry at times. I've gone over most of it myself. Councilman Hale has the right idea by having coffee in front of him. I highly recommend it for reading that. Do you have anything else, Mr. Gullo?
No, that's quite enough for me.
All right.
I agree.
Well, if you thought that was dry, buckle up. Coming into old business, we do have one item of old business that I wish to address. There was a complaint made against the city to the Open Meetings Compliance Board. A decision was made, and these are the results. The appropriate thing to do is to inform everyone of what it is, and I will do so in whole. So get your popcorn ready, and here we go. Official opinions of the Compliance Board. A complaint alleges that the mayor and town council of the city of Taneytown violated multiple provisions of the Open Meetings Act with regard to meetings on February 9th, 2019, September 10th, 2018, and October 3rd, 2018. Number 1, allegation that the council violates the Act's notice requirement. The complaint speculates that the council's sole method of providing notice is online. The complaint then asserts that the council's online notice is incomplete because, even though all of the required information and a link to the agenda appear on the city's online events calendar, another part of the website does not specify all of that information. The complaint does not address the council's other methods of giving notice. We find that the city's notice on the events calendar complies with the Act. Moreover, when a public body uses multiple ways of posting notice, a practice that we recommend, a complaint about only one of those methods seldom states a violation of the Act. C 13 OMCB Opinions 9, things that no one's going to look up, but I promise you it's there. Finding no violation or website notice lacked some information because a public body had given reasonable notice by another method. The Act does not require public bodies to have websites, does not require them to post notice online, and does not micromanage the way in which a public body organizes its website when it does use it for posting notice. The submissions do not establish a violation of the notice requirements set by subsection 3206. We commend the council for using multiple methods of providing notice and for making its agendas available through a link on the event's calendar. Number 2, allegations regarding the council's preparation of a written closing statement before it closes its meetings. Before closing a meeting, the public body's presiding officer must prepare or approve at the time of the vote to close a written statement or closing statement that contains 3 items of information: a citation to the provision of the Act that permits the closed session, a list of the topics to be discussed, and a statement of the reasons for discussing those particular topics in closed session, subsection 3305D. It appears that, until late 2018, the council's closing statements routinely omitted the council's reasons for closing the meeting and sometimes omitted the topic. The October 10th, 2018 closing statement, for example, merely recites the words of the statutory exceptions. The council thus violated subsection 3305D by omitting some of the required information. Now, the council uses the model closing statement posted on the Open Meetings webpage of the Attorney General's website. That form has been formatted in such a way as to prompt the preparer to include the required information for each topic to be discussed. Using the February 9th, 2019 form as an example, we see that the reason for closing is no longer omitted. Still, because the form is apparently pre-prepared for the council, our prior guidance on the use of pre-prepared closing statements might be useful. In a nutshell, we have encouraged public bodies to consider, when voting to close, whether the form adequately states the council's own reasons for excluding the public from the discussion, as the discretionary decision to invoke an exception lies with the members of the public body, not with staff. We also refer the council to Chapter 5 of the Open Meetings Act Manual for its guidance on describing topics and reasons for closing, and for its practice notes on avoiding closing statement violations. Number 3, allegations regarding the council's closed session summaries. When a public body has closed a meeting under subsection 3305, it must include in the minutes of its next open session a summary of the closed session that contains certain information, subsection 3306C2. As explained in 10 OMCB Opinions 57 and 60, a public body may adopt as its closed session summary a separate document, often a closing statement updated to show what actually occurred, so long as that document is attached to the open session meetings, or if the minutes are posted, the minutes contain a link to it so that the public can find it. Here, the council publicly adopts a summary or record of each closed session. Judging by the documents submitted to us, the summary provides the requisite information in considerable detail, and the presiding officer reads it aloud in open session, which the public can view on video. Formerly, the council adopted the written summary as a document separate from the open session minutes and did not incorporate the summary into the minutes. The council now includes the closed session record in its open session minutes. As noted by the complainant, the detail that the council provides in its summary shows that the council followed the Act's intentions regarding the disclosure of the events of its closed sessions. However, the council's former practice fell slightly short of compliance with the Act and therefore violated subsection 3306C2. Number 4, Allegations that the council's discussions in its September 10th, 2018 and February 9th, 2019 closed sessions exceeded the exceptions cited as authority for the sessions. The Act requires public bodies to meet publicly unless the Act expressly provides otherwise, subsection 3301. Section 3305 provides 15 express exceptions to that openness requirement. Once a public body has closed a meeting in reliance on one or more of these exceptions, as listed on the written closing statement, the members may not discuss during that session matters that do not fall within the listed exception or exceptions, subsection 3305B and D. Here, the complaint alleges that the discussions in the Council's September 10th, 2018 and February 9th, 2019 closed sessions exceeded the scope of the legal advice exception, which generally allows a public body to receive legal advice on an issue in closed session, but requires them to consider the issue in open session unless another exception applies and has been cited on the closing statement. The complaint omits the fact that subsection 3305B7 was not the only exception that the Council relied on to close the meetings. September 10th, 2018 meeting. On September 10th, 2018, the Council closed its meeting to discuss how to handle an anonymous letter in which someone alleged that the City Police Department employees were engaging in misconduct. The Council cited 2 exceptions as authority for closing that meeting, subsection 3305B7, legal advice exception, and 3305B8, which permits a closed session to discuss pending or potential litigation with staff, consultants, or others. We find that the meeting, at which the Council both received legal advice and discussed the allegations, fell within subsection 3305B8 concerning potential litigation, as well as subsection 3305B7. However, it is not clear that the discussion was subject to the Act at all, or whether instead it fell within the administrative function exclusion to the Act. Because this particular municipality's charter places with the Council the authority to operate and maintain a police force, the handling of the anonymous letter may well have fallen within the Council's administrative function. If that was the case, the constraint set by subsection 3305 did not apply to the discussion, and subsection 3104, requiring certain disclosures, would have been the only provision of the Act that did apply. I'm skipping a lot of the references that aren't going to help you right now. Either way, the Council's discussions during the September closed session did not violate the Act. February 9th, 2019 meeting. In late January 2019, the city's police chief resigned. According to news reports, he had been charged with transferring and possessing illegal machine guns in violation of federal laws. On February 9th, 2019, the Council held a closed session to discuss 2 sets of topics that pertain to the conduct and operations of the police department. The Council cited 2 exceptions. First, the Council cited subsection 3305B1, which permits a closed session to discuss personnel matters that pertain to an individual employee, to discuss the resignation of the police chief and status of police personnel and vacancies related thereto. The Council also cited subsection 3305B7 for the receipt of legal advice on FBI investigation related to the City Police Department, and stated that the discussion of the legal implications of the FBI investigation and the legal advice given to prepare a response thereto are protected by the attorney-client privilege doctrine. Afterwards, in its summary of the closed session, the Council listed the topics discussed as legal advice on the FBI investigation and its legal implications, measures to address concerns raised about the department and the legal practicality and implication thereof, including issues related to the LEOBR statute. The Council further reported that it had discussed the following personnel topics: the police chief's resignation and the events relating thereto, including the vacancy created and the implications of such a vacancy, personnel matters related to certain police department personnel, and selection of an interim chief. Additionally, the Council disclosed it had adopted a motion to ask council and law enforcement personnel for an outside review of the police department's policies, procedures, and general orders, and to ask the Maryland Police Training Commission for an audit of the police department's training records. We find that the legal advice exception applied to legal counsel's advice on the federal investigation into the police department, on issues related to LEOBR, and on the legal practicality and implications of measures that the council could take. The council's discussions about particular police department employees and the appointment of an interim chief fell within the personnel exception, as would have any discussion about how LEOBR applied regarding the employment or discipline of particular individuals. The request for an audit of training records appeared to have been an exercise of oversight over current operations. Therefore, that discussion fell within the administrative function as described above and was not subject to the Act. The council's decision to ask council and law enforcement personnel to review the police department's policies, procedures, and general orders gives us more pause, particularly because we do not know what purpose the council intended the review to serve. Going by the description contained in the summary, it seems likely that the council's action regarding that review went beyond the mere receipt of legal advice, and that the discussion had thus strayed into the council's own consideration of future policy-oriented changes, matters that went beyond oversight over current operations. We find that this portion of the closed session did not constitute an administrative function and exceeded the scope of the legal advice and personnel exceptions. Generally, once a public body has received its council's advice on an issue before it, the public body must consider the issue in open session unless an additional exemption applies and has been cited in advance, or unless the discussion is excluded from the Act. Quite possibly, the council's discussion would have fallen within subsection 3305B12, which permits public bodies to conduct or discuss an investigative proceeding on actual or possible criminal conduct. However, the council did not cite that exception in advance and therefore could not rely on it. We're almost done, I promise. Number 5, allegations that the council's discussions in its October 3rd, 2018 closed sessions exceeded the procurement exception provided by subsection 3305B14. The procurement exception, subsection 3305B14, permits a public body to close a meeting to discuss, before a contract is awarded or bids are opened, a matter directly related to a negotiating strategy of the contents of a bid or proposal, so long as disclosure of the discussion to the public would adversely impact the ability of the public body to participate in the competitive bidding or proposal process. The exception presupposes an ongoing competitive procurement process. Also, in a rare case where a competitive procurement has been canceled but will soon be reinitiated, we have stated that the exception could apply to discussions about a stopgap contract that are so intertwined with the impending procurement that disclosure would harm the public body's ability to participate. In both events, the public body has already decided to procure the goods or services and to embark on a procurement. Regarding the exception narrowly, as 3305A requires us to do, we have stated that the procurement exception does not extend to all matters of negotiation and compromise. It is limited to the competitive bidding or proposal process. Here, the council invoked the exception to discuss an organization's proposal for renovating a city-owned building and raising the funds to do so. The organization had presented its proposal during a public meeting. The council had instructed staff to evaluate it, and according to the response, the council met in closed session so that the staff could provide its input regarding the matter and develop a strategy to effectively negotiate with the organization regarding their offer. The response states that the council needed to discuss the offer before accepting or rejecting it and to determine whether other terms, parties, or issues that could be considered. Further, the response explains, if the council rejected the offer, the disclosure of the discussions would hamper a future procurement process because potential offerors would have information about the city's prior negotiations. Public bodies have long pointed out the difficulty of negotiating contracts in open session, and we have long pointed out first that the process of adopting a contract is expressly subject to the Act as an advisory function, and second, that the legislature has not provided a generally applicable exception that would permit public bodies to perform that function behind closed doors. Thus, it is not for us to stretch the procurement exception to contract negotiations that, if unsuccessful, might lead to a decision to hold a procurement sometime in the future. Instead, for the exception to apply, the public body must be able to identify a tangible connection to a particular procurement in which the public body expects to engage. Accordingly, we find that the council's discussions about the organization's proposal for the use of the city building exceeded the scope of subsection 3305B14. Conclusion. We find that the council violated subsection 3305D regarding the adequacy of its closing statements. subsection 3306C2 regarding the incorporation of its closed session summaries in its open session minutes, and subsections 3301 and 3305B regarding the closed session discussion of matters properly discussed in open session. The council did not violate the Act's notice requirements. Finally, we commend the council for providing the public with detailed disclosures about its closed sessions and with streaming video of its meetings. Despite the violations we have found, this does not appear to be a public body that conceals from the public the subject matter of its closed sessions. This opinion is subject to the acknowledgement requirements set forth in subsection 3211, Open Meetings Compliance Board. So that can be put to rest. I thank you all for hanging in there with me as I read that. I felt it was important that it be read in its entirety so that you knew exactly what was decided. There were very minor mistakes made. Moving forward, all of those will be avoided, and we'll have a better time at this. Council, do you have any questions regarding that Slumberfest I just read?
Well, just a brief comment in that I think, you reading that was important because it demonstrates, the degree to which we do our best to, follow the letter of the law in everything that we do, because we want to be transparent and ethical. We want to be accountable, and we want to be, literally as transparent as we can be. And, you're reading that in addition to the sections, the subsections, the references, all of those things demonstrate that, it really can be tricky sometimes to navigate through that. And, I second what you've said, Mayor, that, we're going to continue to do our best to avoid repeats of such mistakes in the future.
Very good. Thank you, Councilman. Moving on to things much lighter and less of my voice. Under new business, monthly financial report. Council, do you have any questions, comments regarding the monthly financial report?
Yes, sir.
Very good. Moving on to the accounts payable up for approval on Monday. Any questions on the account payables?
Yes, sir.
All right, hearing none. I'm going to be nominating some people Monday night to the council for appointments of boards and commissions. After the initial list, I received feedback from the council. There is one name that I am going to remove from it for further consideration. You'll see an email about that, but please look over the list that I gave you, and if you want to talk about it before Monday, please do so. Otherwise, I'll have those up for nomination and seeking your approval. Also under new business, for July, we need to figure out when we're meeting in July. Wednesday, what would normally be our workshop is July 3rd, the evening before Independence Day. Does the council still want to meet for a workshop that night, or do we simply want to have just a meeting on July the 8th? Discussion may proceed.
Well, if I could kick things off, I don't think it would be necessary to have both meetings in July, not just because of the holiday, but given the fact that, some of the things that we've discussed tonight, for example, when we were talking about the downtown ordinances and we were considering separating the discussion of drive-throughs from what's in front of us, I think that precludes having to have does not necessitate us having to have a workshop meeting, because that would be something separate than what we have before us. We've had meetings in the past where we have held both public hearings and votes within the same evening.
Mm-hmm.
Based on the fact that we also have, light agendas during the summer, I don't think that 2 meetings in July would be necessary.
And that's what we would end up doing on July 8th, would be holding the public hearing and the vote for the zoning amendments, which is perfectly acceptable. Anyone else have any input, or are we good to say we're having 1 meeting in July and that will be on the 8th?
1 meeting is fine, if that's what everybody else wants.
All right, so it shall be. We will not have a workshop in July. We'll have 1 meeting on July 8th. For the clerk, we will advertise a public hearing on the zoning amendment for that evening. All right, anyone have anything else for new business? Yes, ma'am.
Councilman Vigliotti wanted to address the dump truck under old business.
Thank you, Mayor Pro Tem.
Oh, thank you very much. Bigliotti, go ahead.
Thank you very much. Just the note that the new proposal for the dump truck purchase is going to be several $1,000s less than what we had previously budgeted for that purchase. And my comment is really a question about whether or not that would require a budget amendment because the amount would be less than what we had budgeted, or whether we're good to go as is.
We're good to go.
Okay. That's it.
Jim, would you explain the first figure, the 83, is that part of the, what is that? I don't understand those.
I think it separates the
What is
vehicle.
it, what are we separating here?
It's the truck from the actual dump portion,
Is
correct?
that correct? The truck
It's
and then the
right,
dump?
the chassis versus the dump bed and the plow and spreader.
Oh, okay. I just thought it was all one price. That's it.
All right. And they are seeking our approval for that Monday evening, is that correct, Mr. Wyprecht?
Yes, the lead time on these vehicles is several months. So while we would like to go ahead and order this, obviously we won't be taking delivery until FY20.
Okay.
But because we've been made aware of the time between ordering the vehicle and delivery, we'd like to go ahead and get it ordered and get it in the works so that we'll have it before cold weather.
Okay. Very good. To the clerk, if you would just have that on the agenda so I don't miss it again, that would be great. Thank you. Any other new business from the council you'd like to bring forward? All right. Public comment for agenda items. Out of the many things that we discussed this evening, we do welcome public comment for those. We'll keep the same rules as previous. We'll do the 3 minutes, identify yourself and your address, and we're off.
Marvin Flickinger, 80 East Baltimore Street. You were talking about the proposed ordinance of gambling, tattoo parlors, and adult bookstores. Would the gambling part of that include the Lotto and Keno that would not be allowed in the local business area?
It has to be its primary purpose.
Pardon?
It has to be the primary purpose.
I don't understand.
Meaning, it has to be like a gambling parlor. Like Keno is done as a thing as part of other places. Like if you go to a restaurant and they have Keno, the primary purpose is food establishment with Keno. Follow me?
But on the gambling side of it, when you go to an off-track betting parlor, you bet $2 on a horse, you might have 10 horses in a race, you got 1 chance out of 10. These people here go to buy a lotto ticket for that big lotto, and they got 1 chance out of 3 million. Now, which is the worst gambling, and why would you even, and furthermore, off-track betting power would never consider downtown anyway because of the parking, so that's, that eliminates itself. I don't know why you're including, and tattoos, I don't know how many in here's got tattoos. I hate the things myself. But I was at a restaurant the other day, and I bet you 90% of the people in there had tattoos. So it sounds like there's something wrong with tattoos. It is for me, but not for these other people. So why are you taking it out on people that like tattoos? People got tattoos they don't even want to show you, I tell you that right now.
Well, tattoos are not, I specifically asked, tattoo parlors are not a part of the overlay process.
Correct.
It just needs a special exception.
Which is not unusual.
I want to include the gambling and the tattoos along with adult bookstores. I think there's quite a separation there to me.
Well, those are separate things.
They are separate.
It's all coming under one ordinance or one, under one ordinance,
Yeah.
but they're separate things
they're
within the
separate.
ordinance. They're happening in different parts of the code.
Yeah, I understand that. But
Okay.
I don't know why you wouldn't separate, knock the other two out and just have the adult bookstore separate from, and let the others locate.
Actually,
Where the off-track
did.
betting power is not going to
But-
come downtown, I tell you that. Nobody's going to do
Right,
that.
but that's exactly what we did.
And the tattoos, people want to do it or they wouldn't be doing it. So what's so wrong with it?
No, we're not saying anything's
These
wrong.
vacant stores up.
Marvin, they actually are separate.
Well, okay.
Right.
Anyway, that's my thoughts on it.
Okay.
I hope you don't show so much hypocrisy in your ordinances, and that's what I think this is.
Anyone else have public comment on agenda items? Okay, hearing nothing further, I'll ask the council for a motion to adjourn.
So moved.
Is there a second?
Second.
We have a motion and a second to adjourn. All in favor say aye.
Aye.
All opposed say nay. We are adjourned.